this commission. That's why we brought it this way, to have a public hearing and have it exposed to. And I'm going to pull one of these stunts where I hope I can. Okay. This is the alley, the dirt road that exists through here. Reasons for why a city may not want an alley. This was dedicated originally in 1883. The additional 4 feet on either side occurred using 443 from an expansion by condemnation by the additional 4 feet in 1912. Things have changed along there. As we've seen, the property all around this Quonset hut in question is owned by one owner who has agreed with this provision. It's in their best interest. They have illegal parking. We have, especially during interest bank events, which people are on their property trespassing. They just don't like it. The only way to accommodate this is through the closure of it. I know that Mr. Foster had indicated about moving this access in the front of the property. If you look here, if we were to move it to the east, we would be right in the middle of all those utilities. And we don't own it, so we can't move it. This is where we have it. And it's a direct access to the front of his Quonset hut. This is, as you'll see down through the side of the property here, there's a chain link fence that runs along roughly the property line. He has illegal storage between the fence and the Quonset hut. And you can see there's actually 2 vehicles wide here. Some more of the storage. There in the back, this has been brought up, that this is the south side of the Quonset hut. The owner indicated there's a separate address. I checked with MAPC, who's the purveyor of all official addresses in the city, and there's only one address for this property that's recognized by the city. That's a 212 East Mosley. Admittedly, in subdivision, when you look back here, he was talking about needing access. He's got some room there. Now, if you took concrete pillars and put it right on the property line, he would not be able to have access to the south of his property except through what we're proposing in this situation. He's admittedly saying that his access is through, quite frankly, trespass, using somebody else's property. Get some more of the alley there. You can kind of see, I don't know where, sorry, the map that you have on your table will show the location of the Quonset hut on the newer one, on the, there we go. Shows where the Quonset hut is in relation to that. There's approximately 20 feet from the alley to the side of his Quonset hut. He will get an additional 12 feet through the vacation of this alley. He'll have access from the back south, and then approximately 32 feet, give or take, up to the front. His access right now is only coming in either this way or this way, and then he's got a chain link fence gate right here. So he has to turn in here to get into his Quonset hut at this point. We feel like his access through this is enhanced. He's going to have more property on the side to navigate up and down through here if he needs to get to the south. We do not feel he's been harmed by it, and we feel like his position will be enhanced through the improved access. And I can stand for any other questions.
Mr. Green.
So you were saying that
It's working. Yeah.
Okay.
Go ahead.
all of the surrounding property is owned by one
Yes.
entity?
Yes, this is all vacant property here. This down here is used the old ice house, I believe is what they call it. And then this property here, up through here and here. In fact, we were able to get this property from the owner because of their desire to have this alley closed.
So the vacation process, if you had what is the benefit to the city of Wichita? Why didn't the property owner that surrounds the entire alley except for the one property, why didn't they apply for the vacation?
Well, clearly, these two owners are not going to agree, okay? Secondly, there's a lot of reasons why city, now this is Yeah, this is one of the first ones. The last I could find that the city did this was in 1948. Okay, so this is not a common procedure. It's been done around the state by different cities that, you know, and very little case law associated with it's been done. We have situations where there's been a street dedicated, it's never been utilized, it's somebody's backyard. The city would be responsible for maintaining it. We don't have the funds to do that. This is a dirt pothole road through here. We don't have the funds to pay, to pay to maintain it as the status that English is now at, and even further north on the subdivision. Besides it not being used, there are a number of other reasons why the city may not want the liability associated with the particular street. This is all undeveloped land through here, and this just cuts right down through the middle of it. It's not necessary. This gentleman here that owns this property has more than adequate access that's going to be provided to him, and it will benefit the entirety of the property, all of these properties, by this vacation.
Additional question, Mr. Blick?
So based off that last statement, how I take it is, if the city doesn't have funds to maintain an alley, then they could possibly just close an alley down if they'd like to?
Well, again, there's no reason it needs to be stated, but there are certain circumstances, because of changed circumstances. There's been a lot that has changed in this town since 1883. There are going to be alleys and streets that have been dedicated that are no longer necessary or useful. And so, this is something that, again, this is not new. That's why I wrote the article, because it's kind of unique. And, but it provides an avenue for the city to pursue enhancement of property. And again, we're not an adjacent property owner. So the avenue, the most specific direct statute in question is 13443 as opposed to 12505.
Just for clarification, Mr. Bill Johnson, you weren't a member of the MAPC in 1948?
No, I feel like it.
Mr. 49.
Mr. Green?
Yeah, I've got one more question on this, and there could be more, who knows. On this access easement dedication, what's the city's plan with that, and how are you going to address the specific dedication? Are you going to pave it? Are you going
Yes.
to maintain it?
It's 24 feet, and pursuant to fire regulations, it has to be at least asphalted. So it has to be maintained that way. And all of that will be worked in conjunction with this owner, because you did indicate the fences and stuff that are around there. Obviously, this is with permission of the owner of, 85% of this property.
And I believe English is paved at that point, so
Yes,
I
it
guess
is.
there
It
would be
was part of the
appropriate curb cuts
Cargill
made. And
process. This is very nicely paved and curved, and there's a picture we had of there, and then all the way north of here as well.
in fact, I think the alley to the north is paved, but it
Yes, it
goes
is.
to a parking garage.
Right?
Mr. Nix?
So I'm a little confused. The city wants to vacate this because of all the traffic accidents we saw in the original report of the subcommittee, or we want to hand some property? Which is it? Is
It's
it
all
both?
of the above. I mean,
It's all of the above, huh?
we've stated this for safety factors because it is within 150 feet of a major intersection. When we said it's not significantly or statistically significant, it doesn't mean it's like the highest amount of accidents that occurred in any intersection in the city. That's what that means. This has got a high enough level here. We've had complaints by the owner here of the through traffic that it's going through, and some other factors that are safety related. But again, please understand, legally, we didn't even have to state why we wanted to do this, but we just felt that this was the most obvious reason to start with. Yes.
Ms. Miles?
So help me understand, Mr. Joe Johnson wants to understand as well, those properties that are there on on Washington, those 1, 2, 3, 4, well, we'll just take the first 4 properties. So if those are developed in the future, say for instance, the current owner decides to sell off those lots and they're developed individually, they'll all have to have ride-out access, correct?
Correct.
And will they would that not create as much danger as what this alley does currently?
Well, I can't really speculate as to what the development would look like and the access through here. I don't know if it's going to be one, if it's going to be, those look like lot depth of ratio nightmares all the way through there. So again, I really can't speculate as to what you're saying. There's going to be access through this way. There does not need to be access on both sides. But this could be, one property going this way. And so, and they would have an ingress, possibly using this as an ingress to the new property, but I don't know. I can't speculate to that.
Additional questions for the applicant? Mr. Bill Johnson.
I can understand what you're trying to do here. I'm going to approach it a little bit different. Presently, with the alley being 24 foot wide, that's a legal two-way drive. The 19 foot from the alley to the building, you can have parking spaces there, even though he may not be using it that way. By going the other way, it looks like to me we eliminate a lot of future parking for that existing business.
Additional questions for the applicant? Seeing none, thank you, sir.
Thank you.
Anybody from the audience wish to speak on this issue, please come forward, state your name and address for the record, and you will have 3 minutes.
Thank you, Mr. Chairman. Kim Edgington, 2532 North Cardinal Drive, Wichita, Kansas. I apologize that I was not able to represent Mr. Brand at the subdivision committee meeting, but I appreciate the opportunity to address you today. This is really rather unprecedented if we look at the history of 1948. The safety concern itself really does not seem to be an issue. We did some further research into this and found that of the 10 accidents per year over the last 14 years, only one of those occurred at the alley. So there's really no evidence that the city has explored any other options. And this has existed for decades. I would like to go to the aerial if I could. Yep. You can see that, essentially the same situation exists right here, a half a block to the east, with an alley that's within 150 feet of a major intersection. This exists in countless places in Wichita, and I don't see that we've ever pursued this kind of action other than at this location. My client indicates that there is where's the mouse? There is a loading dock on the south end of this building. Inside that building, there's a concrete platform. He does have direct access to the alley on the south end of that building. The access easement that's being discussed here on the north really does not provide him any use. Yes, he will have additional room alongside this building, but it becomes a very tight maneuver to get to the south end of this building. The terms of that access easement and as how it relates to his property have not been presented to my client. He has not had an opportunity to even review those. We feel that he should be able to review those and approve those. If in fact there is through traffic occurring on, in this alley, we feel like would be the city's responsibility to either sign that for no through traffic or to police that in some way as the governing municipality. And it is also the city's responsibility to maintain that access. My client owns a piece of property that is his only means of public access is through a legally platted alleyway. The business he has here, Applied Technology Development, has been in existence since 1975. He feels like the reason maybe that this vacation wasn't done through the 12-
Your time has expired. Do you need some more time?
if the board pleases, may I have an additional 3 minutes?
We can issue two, but that'd take a motion. Is there a motion to extend 2 minutes?
So moved.
Okay. Those in favor signify by raised hand. You have 2 minutes.
Thank you, Mr. Chair and Commissioners. Now I need to get back to my train of thought. I apologize. The existing property owner did not file the vacation for this. And the reason being that this property owner, my client, would have had to have been party to that vacation application. If he did protest, therefore it would invalidate the vacation proceedings. While 13-443 does allow for the city to vacate streets, alleys, right-of-ways, there's the process that they have chosen, and we do appreciate that they did send this through the proper legal process. The process of having a public hearing in front of you still should take place and still should take into consideration the needs of existing property owners and the condition of the way their property is developed. And the city, in this case, we feel has an obligation to provide a public right of access to this property. We also would put forth to the board that if there is to be a legal determination made on this, and whichever state statute should apply, that city's own legal counsel should not be the party that makes that determination, given that the city is the applicant in this case, that maybe that's kind of a conflict of interest and regarding the overall process, how we've gotten to this point. In light of all of these things, the fact that there has been really no overwhelming evidence that there is a public safety issue, that the fact that there is no, a lack of maintenance on the existing alleyway, the through traffic, those could be traced back to, lack of care and maintenance on the part of the city. So we would ask that the board deny this case.
Your time has expired. Thank you. Questions for the applicant or for the speaker? Mr. Hartman?
Kim, where does your owner get access now in park when he uses his building?
I can't, it's hard for me to see this. He's got a gate right here that he can come in and park behind this building, which he accesses through the alley to the south.
Additional questions for the speaker? Saying that, thank you. Is there anybody else in the audience wish to speak on this issue?
Good afternoon, Mr. Speaker. Scott Rigby.
Scott, just a second. You're a part of the applicant
I'm with the city, yes.
city? Okay, is this going to be your rebuttal?
No.
Okay, I need to hold off, see if there's anybody else that wishes to speak. My understanding of the rules, right, that the applicant can't speak. So,
By the bylaws, the applicant has had their opportunity to speak, so it would need to be part of their rebuttal time, which would be 2 minutes.
okay, you have 2 minutes.
All right. I think, in respect for Jeff, I'll keep mine short to a minute. Thank you for the opportunity to speak. Scott Rigby, Assistant City Manager and Director of Development Services. The city took this action. Some people may say this is a new tool. It's not a new tool. It's just been a tool that hasn't been used very much. We think it's a worthwhile tool to utilize in this situation to allow the future redevelopment of this larger site. One of the concerns we've heard is traffic access, not just from this point looking backwards, but looking forwards with the development of the Cargill facility, with the new development going on at Union Station, the increased importance of Waterman in the intersection of Waterman and Washington, that safety will only continue to be a driving concern, and the opportunity to eliminate an underutilized alley this close to the intersection would be safety-wise, but also provide an opportunity to see the redevelopment down the line for this overall site. There's been questions about the depth of the site. That does pose some challenge to development potential. Whether we're acknowledge that or not, it's the opportunity to provide development opportunities in our downtown, which we've seen over the last 10 years of resurgence of development, and that largely creates how do you create developable pieces of property, and the opportunity to have underutilized pieces of public property that's not necessary to be vacated in order to provide greater development opportunities for either the Quonset owner or for the larger property owner is a desire for us.
Thank you. In the meantime, I just wanted to point something out that, I don't know if I can find it fast enough, but bottom line is the access that is currently being used right now, the only access to the south is through the trespassing on this property. It is fenced all the way around. There is a gate up on the north side of it. So the public access to this property, the only public access right now is right here, which will be greatly enhanced through the emplacement of this one right here. So I just wanted to point that out from what was said before.
Any questions for the agent?
Thank you.
Mr. Green?
Yeah, Mr. Foster, go ahead.
Okay, Mr. Foster?
I want to come back to providing access to the Quonset hut property. Is 24 foot going to be the minimum width required to get down to this property and allow for fire?
That was, according to fire, 24 foot is what they require.
So in order for, let's say it did shift over towards the alley, it would have to extend further south, I would assume.
Not according to fire. This was more than adequate for them.
I'm just trying to think of the convenience of access for the Quonset hut owner. Because it was demonstrated at the subdivision that coming straight in off of there for his activities didn't work too well.
Well, it's kind of hard to understand why it didn't work too well. I don't remember hearing that. I mean, his access right here is a little gate on the side of his building that he has to come down this way, turn and come in and go that way versus straight up and down. So I don't remember hearing that that was not going to work well in the front part of his property. The back side of his property, he kept talking about access back there. But again, I want to point out the fact that the only access he has there now is through trespassing on this property back here where the ice house is.
Certainly.
If that was blocked off, he would have no better access than he has now. We're enhancing that by the additional 12 feet.
I think
Excuse me.
I'm going to ask I won't do it now. We'll wait till we're done, but I do have a question for the owner.
Okay. Mr. Blick?
I have a question for staff. So based off this south photo, this 24 foot that they're looking at proposed, they're gonna have to do a curb cut and street cut right there to be able to make that. Is that correct?
That's correct. You would have to.
And does that work with the same with the whole drainage and all that stuff that's in there? Are they gonna have to add anything extra or anything for the runoff coming from the south side onto the north or not or anything? Or is it gonna be sloped or anything?
That'll all be addressed by the terms of the access easement, which has not been provided as of yet. But the conditions in here will be required to be submitted prior to this going to council.
All this would have to be according to city standards with engineering, so.
Any additional questions for the speaker, for the applicant? Seeing
I'm
none?
trying to figure out, right now, the alley is 16 feet. 4 feet's
20.
on hit.
It's 24 feet.
Well, okay, but he's got 24 now.
Correct. Historically, what we were talking about is this alley back in 1883, when it was first dedicated, was 16 feet. In 1912, an additional 8 feet was added to that. So the width that you're seeing here roughly is 24 feet.
So how's he getting more?
More. He would get the 12 feet, which is half of the alley that it runs adjacent to his property here. By law, under Kansas law, when the alley's vacated, that proportionate share of the alley would go to the adjoining property owners.
But right now, he has 24 feet to maneuver in.
Correct.
But well, I see what you're saying, but you know, what I'm saying is we're not depriving him of access by any means whatsoever. And there's no guarantee that, you know, what, the way he's using this now, there's a fence here running up and down through there. He's not utilizing the alley except for right up through here or through this private property back here that he's using.
Mr. Nix?
Did wanted to point out one thing, just to be clear, on the conditions, number 2, the use of the restrictive covenants is a mechanism that's utilized under 12505. In this case, the city would exercise the use of quitclaim deeds to the respective owners of their proportionate shares. So that would, I'd request a change in number 2.
Not seeing any additional questions. Thank you. Oh, Mr. Nix, I'm sorry.
From the edge of his building to the middle of the alley, he's got 31 feet, does he not?
Okay, yeah.
Is that true?
Yeah, that would be about right, roughly.
So if he removed his fence and the vehicles that don't run, looks like, then he'd have 31 feet.
We're calling that a self-imposed hardship by the fact he's got illegal storage along the side of his unit. If he were to remove those, he would have 31 feet.
But even if he removed it and he went around to the back side of the thing, he couldn't get in there without trespassing on the property by the
Now,
ice house. Right?
he'll still have room, apologize, let me see if I can find the right one. Oop, going the wrong way. See, he's got access right here. If you look on the one map that I handed you on the, it's at your desk, there's access through here. And then he can go out an additional 12 feet and go up and down that way. This, again, this is all just storage that he would have to remove to have access, but that's his obligation in that circumstance.
Mr. Hartman?
So on this color drawing here, it shows a fence around his building. Is that his property line?
Best I can tell, roughly, yeah.
So it looks to me, it doesn't have a dimension there on the south side, but to that fence to the building, looks it's like at least 19 or 20 feet there.
This is a picture of it right here. It's a
Yeah.
pretty good sized truck with some clearance there.
So he owns from the fence
Yeah.
back to the building.
Right, exactly.
Okay, so he does have access there.
Correct.
Any additional questions? Thank you.
Thanks.
Bring it back to the commission. Mr. Foster?
Mr. Chairman, I did have a question for the owner on the Quonset Hut property regarding the access easement. Could they come and address 2 questions?
Yes, Mr. Foster.
Question 1 is, I understood when we looked at this at subdivision that the owner was not involved in determining the access easement dedication to the north. Is that correct?
My client, no, was not involved in the development of the access agreement or any of that process.
And the second question is there a better access and where might that be?
Well, his preferred access is through the existing legally platted alleyway that's been in existence since he owned the property. Our feeling is that, you're still gonna have an opening along English Street. It's just gonna move over to the west a little bit, so that hasn't really changed the situation there much, and it just, creates an inconvenience and a nuisance of trying to get around his building rather than where the alley comes in right now and where his access points are. He does have, this fence is a movable fence, so he brings stuff in here on this south side without trespassing on property that he does not own, using that approximately 20 feet between the Quonset hut and the edge of his property. You can see that is not permanently fenced in. Those are just posts that can easily be taken up and moved. The fencing that is more permanent in nature is here behind the door.
Take care of your questions, Mr. Foster. Any additional questions? Thank you.
Thank you.
Mr. Green?
If there isn't any further discussion, I still haven't been convinced to why the city would step into what Mr. Van Zandt even represented as a disagreement between two property owners, and that it would never happen if it was just left to the two property owners. The safety issues, I'm not seeing it, which is the basis for this request in the first place. And so with those two reasons, I'm going to move to deny the request.
Second.
We have a motion and a second. Further discussion? Mr. Blick?
I'd add on to that also is, when I was looking at the major safety concerns, I also was out there at that site and looked to the south, the alleyway to the south. I've looked at the alleyway that's on the east side of Ketch, and I've seen big trucks that were going over there, and I thought maybe as a major, safety was the alleyways. But then after I watched Washington and all the speeders that were coming down Washington off the highway going northbound, I could see where that was a safety concern. The major safety I see is on the city of Wichita side, that they're not maintaining this as an alleyway. So that's why I'm saying.
I guess for me, the aspect of not, my taxes go to maintain that, and I'm not sure I want to maintain it for, when the owner, the majority of the property there doesn't really appreciate the public using this as a shortcut from one spot to another, and then using it for parking. In order to eliminate that, now the city's got to spend time on police officers and maintenance of a street that they don't really get that much benefit from. I can certainly see the city's side of this is why they would want that out. I'm going to be voting against the motion.
I would make a substitute
Mr.
motion.
Foster?
Go ahead, Joe, if you want to make a substitute. I have a substitute as well, so.
Make a substitute motion that we approve.
Second that.
Okay, second by Mr. Foster. Okay.
Can I clarify, one of the things that the applicant brought up was condition number 2, where it requires a restrictive covenant binding the land that's being vacated to the adjoining properties. They indicated a preference to do that through quitclaim deed. Is that part of the motion?
Can you give us legal advice on this?
It could legally be done either way, either by quitclaim deed or by the restrictive covenant, which was in the which was the original condition in the application. I think the applicant has asked that that condition be changed to be a quitclaim deed, and legally it could be done either way.
What would you recommend?
I think at the end of the day, they're going to result in the same. The restrictive covenant may have more protections than the quitclaim deed. Quitclaim deed is only going to transfer whatever interest the city has in this property. By the documents that's been presented, we certainly have, I think there was a ordinance that 4680 that was part of the packet, where we legally obtained property, or staff was directed to obtain the property. So I don't think there's a question that the city owns this alleyway. So whether there's an extra benefit or not, I don't know that there is one.
Does the second to the motion have a preference?
I would ask Mr. Van Zandt to come back to the mic, please.
The restrictive covenant, I looked at it, and it's needs to be redrafted, because it basically just says that they agree to take the property unless the city council does anything they want to change that aspect of it. The other side of it is restrictive covenant requires the adjacent property owners to sign it, whereas that's why this wasn't done under 12505. You're putting it back under a provision of 505, which was not filed under to commence with. That's the basis for the quitclaim deed.
I think that would facilitate the process to go with that then in the motion.
I would allow that substitution.
And I would second that
Okay,
as
so
well.
the substitute motion does allow for a quick claim deed to work in exchange for the restrictive covenant, or restricted covenants, yeah, okay. Additional comments, Mr. Foster?
Yeah, I just want to go a step further. At the subdivision meeting, it was also discussed, it was an all or nothing proposition. You know, given the statutes and things, it's not like you want to chop this up different ways. And also, I'm recalling, you know, testimony from the applicant regarding redevelopment. And so I think there's a broader view here that allows for and aids us in making this decision.
Additional comments? Yeah, Mr. Blick?
Question, statement was made that there was people that were cutting through the alleyway and then also additional parking. I didn't see it in my packet that there was police reports or statements sworn or anything like that that said that. All I had was this traffic accidents. Was that just the statements that were through the city, or was that actually filed or anything like that through the police department? That was actually happening, or is that just speculation that's happening?
That was a statement provided to us from the city.
Through the applicant?
Correct.
Okay, that's what I wondered.
Not seeing any additional questions. We have a substitute motion to approve using a quick claim deed to transfer. Those in favor of that motion signify by the upraised hand. 7 in favor. Those opposed? 1, 2, 3, 4. 6-4 passes. Next item, please. I think if my record right, we're at 4.2, a zone change. Kathy, is that one yours?
Yep.
Good for you.
Oh, really? Okay, so this is,
Let me interrupt you just a second. Let me ask a question. Do we need a bathroom break? We'll take a 5-minute break.
I'm going